think about reproductive rights in our political milieu, it seems like one ideological side of the spectrum is more closely associated with support for reproductive rights, and one side of the ideological spectrum is more associated with opposition to it. So what are those sides? So which side is allegedly more supportive of reproductive rights? Anyone? This is where I cold call you. Yes, in the purple shirt, because NYU's color is purple, yes. The left. So Democrats typically are associated with support for reproductive rights, and who's associated with opposition? Conservatives, Republicans. What if that wasn't always the case? How do we consider, like, we think about these things as so fixed and rooted, articles of faith almost. What if that wasn't always the case? So what I want to do, at least for the first part of this, is perhaps disrupt what we think about the political climate and reproductive rights, and maybe use a little bit of history to sort of think more broadly about what the question of reproductive rights has meant in our history and in our present. And so to do that, like any good law professor, I'm going to go back to 1873. So does anyone know who this gentleman is? Yes? Here in the royal blue? And who is Anthony Comstock? Excellent job reading slides, A+. So Anthony Comstock is, of all things, the Postmaster General of the United States during the postbellum period. He is also a dedicated vice hunter, which is to say that he believes fervently that the United States is in a state of moral decay in the postbellum period, and he is trying to do everything he can to stop it. And he looks around. He has one of the best resources for spreading vice, he decides, the US Mail Service. So he lobbies Congress as Postmaster General to pass a massive law, the Comstock Act, which prohibits the distribution in the US mail of any item that would be considered immoral or could be used for immoral purposes. So this includes erotica, contraceptives, abortifacients, sex toys, and more importantly, any kind of information about using any of these things. All of these cannot be circulated using the US mail. It would be a crime to do so. So it's criminalized, but that's not it. Comstock is not only successful at the federal level, he's also successful in lobbying states to pass what are known as mini Comstock Acts, which criminalize the same things within their borders. So we have this federal law that prevents the interstate transmission of these items through the mail. And then in about 36 states, there are all of these mini Comstock laws that prohibit certain things, including, for example, the use of contraceptives. We'll get back to that one. At the same time, Anthony Comstock is doing that. This woman is trying to do something different. Does anyone know who this lady is? Yes, who's this? Yes, this is Myra Bradwell. Myra Bradwell was an Illinois housewife who did more than just domestic work. She worked alongside her husband, who was a very prominent lawyer in Chicago. And she eventually decided, if he can do this, so can I. So she went and read the law with one of his colleagues. She got the requisite certificate of good character, and she petitioned the Illinois state legislature for a license to practice law. She was denied on the ground that the legislature had never contemplated the prospect of a woman practicing law. It had never been done in the period at the bar in England, which, again, many of the rules in the United States were born of the rules in England. That had never been contemplated, and they just didn't see a way forward for her. She sued, and it made its way all the way to the United States Supreme Court, which at the time was trying to decide the scope and substance of the newly ratified 14th Amendment. And Myra Bradwell argued that one of the privileges or immunities secured under the 14th Amendment was the right to practice a vocation of your choosing. The court, in her case, Bradwell versus Illinois, said, we actually decided yesterday in Slaughterhouse that there is no right to practice a vocation of your choosing. That's not on the table. But that actually wasn't the main action in Bradwell versus Illinois. Myra Bradwell loses because the court is interpreting the 14th Amendment more narrowly. But where the real action is in this concurrence. by Associate Justice Joseph Bradley, where he says, the majority is interpreting the Constitution of the United States, but I'm interested in the Constitution of the family organization. And under the Constitution of the family organization, which is founded in the divine ordinance as well as in the nature of things, women belong in the domestic sphere. And that's why Myra Bradwell can't get a law license, not because there's no right to practice a vocation of your choosing, but because to do so would entirely upset the domestic order and society as we know it. I raise Myra Bradwell's case here in conjunction with Anthony Comstock and the Comstock Law because at the same time, we have two different conversations going on. One about limiting reproductive freedom and sexual liberty, and one about women moving outside of the home into other venues. And they seem disparate, but they're actually understood as connected. Part of the vice that Anthony Comstock saw in the United States and that he wanted desperately to stop was this transgression of what he viewed as very solidified and indeed necessary gender roles. Women trying to move outside of their lanes, outside of the home, to do other things. And he understood immediately that access to reproductive freedom would allow them to do so. So this is all integrally connected.